Have you been contacted by a debt collector claiming that you owe money on an old second mortgage? The Financial Protection Bureau has issued an advisory opinion indicating that debt collectors whose activities are governed under the Fair Debt Collection Practices Act and Regulation F, who attempt to foreclose or even threaten to foreclose on old mortgage debt that might be time barred under state statute, may be in violation of the law. I will discuss this advisory opinion briefly in this video, but before that, please check out this brief disclaimer. This is Ryan Ramsaran, an attorney in Palm Beach County, Florida. Welcome to my channel. The purpose of this channel is to provide general information about the Florida real estate market. It is not designed to provide specific information tailored to any individual real estate transaction. If you need this type of information, please consult with your own attorney, real estate agent, property insurance agent, settlement agent, or any other service provider that you choose to work with for your particular situation. The viewing of content on this channel does not create an attorney-client relationship between the viewer and the law office of Ryan A. Ramsaran, PA. Although every effort is made to provide accurate content on this channel, because the Florida real estate market is so dynamic, there's no guarantee that the information will be accurate when you view it or will remain accurate in the future. The law office of Ryan A. Ramsaran is a title agent with Attorneys Title Fund Services LLC and issues title insurance policies underwritten by Old Republic National Title Insurance Company. The firm also represents companies and individuals in the acquisition, sale, and development of commercial property, such as hotels, warehouses, and industrial property. If you believe my firm might be a good fit to represent you in real estate matters, please see the firm contact information under Details in the About tab of this channel. In addition to real estate matters, my firm also accepts personal injury cases, as well as cases related to the violation of individual civil rights. Please note that these cases will be referred to another law firm. However, under no circumstances will the client be responsible for paying fees or costs in addition to what they would be paying if they only hired one law firm. Again, thanks for viewing content on this channel, and let's get back to the content we were looking at before. Thank you. Welcome back. So for some background, during the lead up to the 2008 financial crisis, some lenders were making mortgage loans to borrowers without considering their ability to repay these loans. One popular loan product during this time was the 80-20 loan. With the 80-20 loan, borrowers could borrow 80% of the value of the home, which would constitute a first lien on the home, and they would also borrow 20% of the value of the home, which would constitute a second lien on the home, which the Consumer Financial Protection Bureau calls piggyback loans. Now, during the financial crisis that occurred around 2008, home values plummeted, and as a consequence, lenders realized that they could barely recoup the amount owed on first lien mortgages, and therefore owners of second lien mortgages or piggyback lenders charged off these loans as uncollectible and would sometimes sell them to debt collectors for pennies on the dollar. The fact that these loans were sold were not communicated to the borrower, and the new owners of the debt would not communicate this fact to the borrower either. Now, in recent years, as home values have increased, some debt collectors have contacted borrowers indicating that the borrowers need to repay these second mortgages along with interest and fees. And if they fail to do so, then they might be subjected to a foreclosure action. It is the position of the Consumer Financial Protection Bureau that these long dormant piggyback secondary loans may be time barred under a state statute of limitations rules under certain circumstances, and that debt collectors who attempt to collect on a time barred debt may be in violation of the Fair Debt Collections Practices Act and Regulation F. It does not matter, according to the CFPB, if the debt collector is aware that the debt is now time barred under a state statute of limitations. If you're dealing with this situation, you should consult with an attorney to determine what your rights are under these circumstances. And in addition, the Consumer Financial Protection Bureau has a way for you to file a complaint for these circumstances on its website. If you're interested in reviewing the full advisory opinion from the Consumer Financial Protection Bureau, you can do an internet search for Consumer Financial Protection Bureau time bar debt. Then you should see a link from the Consumer Financial Protection Bureau entitled Fair Debt Collection Practices Act Regulation F. If you click on this link, you should get access to the full advisory opinion. If this information was of some use to you, please like and subscribe. Until next time, be safe out there.